grading mark stick. So at this point in time, if you want to make sure that you get all your evidence, at least in the sense that it is looked at or ruled upon by this court, they need to make sure that they have all of it so they can go ahead and do that. Now, if you've turned it over and it's now this period of time and they haven't filed a motion, then I'm just gonna continue at this point in time. I mean, I'm just gonna overrule the objection. We're gonna go on. We're gonna go forward because then they had the time and you told it to them, you gave it to them. So I'm just telling you at this point in time. Or, like I said, I'm gonna suck up your weekends. If it's that important, then we'll come in on the weekends and we'll resolve it. And I've already checked with the sheriff, and we can do that, and that will not be a problem. So I'm not looking to do that because that takes my weekend up and my time off, along with my staff and everybody else. But I have got to get this thing moving, and we've got to be smoother and better, as advocates in order to do that. So I know that many of you may be annoyed, but hey, do better. So, Ms. Love, when can you augment this list? Can you augment it by tomorrow?
No, Your Honor.
When can you do it by? You should have a handle on every piece of evidence you probably have.
We do. The court is asking for something very specific, and so our resources, we would use them to give them to the court. For instance, for next week, we could have those done for the next 2 weeks. We could have those done.
By when? Tomorrow?
By Judge, if the court.
I'm telling you,
that would be great, but if the court.
You got other stuff you need.
By tomorrow, then that's what we do. But Your Honor, we'd ask that we not be required to go through and with respect to all of the acts. Ms.
Love, you must act like I was never a trial advocate. I know you all have this stuff together already, and if you don't, I'd be highly shocked. You probably have all this stuff together already. I mean, so just put it on paper and give it out so we can go ahead and go forward. It is not giving your trial strategy. The facts are what the facts are. I'm just sorry. Mr. Sharp, you find something funny with what I just said? Okay, all right.
I'm not doing anything abnormal. Just sitting here listening and paying attention.
Okay, all right. So, in that respect, there's nothing that should be a surprise at this point in time. Friday morning, that's when I want it. We already have a motion to Friday morning by 10 o'clock. I want to see it. Yes. Actually, no, because you all have off on Friday. So that's why I want it Thursday, madam. I want it Thursday because I want to take up your motion. I told you I'd at least give you a day. That's why I want it Friday morning. That's why I want it Thursday morning. So I'm going to listen to your motion, the motion to disqualify, and I'm going to make sure the next 2 weeks of, that means all the witnesses you plan on calling by the 19th of April. I'm also requiring that all counsel copy myself and Mr. Kearns, Ms. Weaver, and me on future correspondence going forward. Because I want to just see what is being sent to each other in turn to satisfy the court's directives as to evidence. And I want it sent, piecemeal, Ms. Love. I want it sent, at this point in time.
What?
In the future going forward, okay, I would like it to be sent, where you do the same thing you're doing with the court's exhibit or the augmentation of your witness list, okay? I want to be able to see what witness you're calling, what act, and the evidence that goes along with it.
Okay.
Okay? All right. Any defense counsel have any comment at this point in time? Let me cover Mr. Matthews. Anything you wish to add, disagree with about the court's instructions?
Not at this time,
So I'm looking for suggestions at this point in time. Mr. Weinstein, Ms. D. Williams, Mr. Harvey, Mr. Sharp.
I believe that you share this opinion, Your Honor, but I just want to be clear. Regarding recordings, as I've stated, there are probably thousands of recordings. I'm pretty certain Your Honor does not wish to have us, and quite honestly, I don't want to do this, go through every recording and file particularized motions for every recording and discovery.
But I'm not going to do it in front of a jury like we've been doing before.
No, I understand.
I'm not doing that anymore.
I understand, but
Okay, so what is that incumbent upon you to do then?
Well, I'm going to reiterate the fact I completely understand that you want to be forewarned about issues. I'm just going to reiterate reality that unless the plan is to have us go through thousands and thousands and write thousands and thousands of particularized motions, we do need the pared down, and I believe that's what the state's saying, but I'm just reiterating, we're going to need the pared down list ahead of time when they seek to introduce recordings so we can file in a timely manner those particularized motions for those recordings. Because to just file particularized motions for every recording and discovery would just be to cast a net that is way too wide, and it would not be time efficient for anyone.
Okay, but you all know now, even though you have thousands of recordings, you do have an idea which recordings are relevant for a particular witness or a particular period, correct?
I would not agree to that. We have.
Why not at this point in time?
Well, because there's thousands of recordings.
Okay, but focus, okay? The thing I'm asking you at this point in time, if you know, for example, witness X is going to be called.
Yes.
And you pretty much know at this point in time, there may be 15 to 20 recordings that are relative to that particular witness. Are you telling me that you true or not true? Is that?
No, I don't believe that's true.
Why would you say that's not true then?
Because that's why I'm saying in a timely manner, and I'm not even suggesting that the state hasn't done this. I'm just trying to bring this to the court's attention, and we need those specific recordings that the state plans to use to be identified to narrow the net, then we can file our particularized motions in a timely manner.
So unless the state identifies them, you haven't looked at them in terms of that particular time period, of that particular witness's recordings?
As Your Honor has pointed out, this is a RICO conspiracy. There's thousands of calls, and I can't believe, I don't believe that Your Honor is saying this, but there's hearsay.
I'm sorry?
There's hearsay.
Uh-huh.
There's inadmissible, there's third-party statements on every single jail call. And I'm certain that the expectation is not that we file motions on every single call and discovery. And Your Honor, I do not know what calls the state finds particularly relevant versus calls they don't. That they're putting on their case, and I cannot forecast their case. Yes, my client, for instance, Ms. Hilton sent me 5 calls in particular regarding my client's calls. And out of thousands, probably hundreds. And I am fully aware of those calls, and I'm not going to dispute that I'm on notice of those calls. All I'm stressing to Your Honor for the smooth administration is, to the extent the state has, that it continues, to the extent that they haven't, that it begins identifying in advance what calls they anticipate using to at least narrow it down so we can focus on the meat of this case instead of calls that they've never planned on using.
I hold that thought.
Yes.
Here's the challenge, Ms. Love. Mr. Sharp may brings up a good point. Say Ms. Hilton gives the 5 calls, but instead of 5 calls on the morning, it's 8 calls. And they haven't identified or listened to those other 3 calls. That's what I got to take up. And that's what usually causes the issue.
We've not done that, Judge. And
No, I'm going to disagree, because that's happened on a couple of occasions. But That's all I'm saying. Mr. Sharp, do you have anything else? So you want them to keep identifying the calls and whatever recordings they wish to do?
That is correct.
Okay,
Thank you.
all right.
Thank you for turning your microphone.
Okay. All right, Mr. Adams or Mr. Steele?
I don't think we have anything to add towards anything. We understand.
Okay, all right. All right, Mr. Weinstein?
No, Your Honor.
Anything else?
No, Your Honor. Thank you very much.
All right. So, all right, and defense counsel, this is, I mean, I know that there's 8 terabytes worth of stuff, okay? But that in no way alleviates your responsibilities to, to listen to as much or to be prepared as much as you can. This should kind of help out in the sense of everybody kind of knows where they are, should be, at least where we're presenting or witnesses. Does anybody have any questions or issues with the witnesses that the state has identified? I know that they have identified the accident and
Your Honor.
sir,
Um,
Mr. Sharp.
I would just like to forecast one issue, and I think we need to talk about this at some point before it comes up. I see that it's not scheduled until May, but witness 89, Sammy Davis. I noticed he is on the witness list. He alleges that he was at the scene at the time of the Donovan Thomas shooting. Your Honor has suppressed out-of-court identifications. I do not anticipate that he will make any in-court identifications. But I would like to have a conversation before he testifies with the court about the proposed testimony and what Your Honor would consider fair game without opening any doors by the defense to violate or to put in jeopardy your prior ruling. I think that there needs to be a discussion outside the presence of the jury.
When did I make that ruling?
I do not have the order.
Do you have a copy of the order? Well, send that to Mr. Kearns, and I can take a look at it.
Yes, Your Honor.
I sent it to everybody, but you can send it to include Mr. Kearns and myself. Going forward, like I said, please include me on your correspondence so I can go ahead and at least be apprised of what is being sent or communicated between all parties, so I can be better informed. All right. Other than Mr. Davis, all right. Does anybody else have any other information or issues that they need to bring to the court in terms of the witnesses that have been identified? We're going to add the documents that are to be called. What I'll do is, Ms. Levy said you'll provide those by Thursday morning, and then the next
That's tomorrow morning. Your Honor.
tomorrow. Yes, ma'am. And I'll just indicate in my order that every 2 weeks the witnesses as well as the evidence list will be reprinted, or I should say will be disclosed for the next next 2-week trial period.
Your Honor,
Sir.
as to whether any of us have any other issues with the witness list, just speaking for myself, as we just received the list 15 minutes before the 11 o'clock start time today, and I in no way mean to say anything negative about the state. I'm sure they stayed up quite late putting this together, if not all night. But I'm going to need more time to look over this list to see if I have any issues, Your Honor.
All right. Well,
Judge, this list is comprised of people with the exception of the ones that I named that
4 or 5 that you've identified is the same
Right.
list that's been provided.
these names have been provided for months and months and months and months,
I don't-
maybe even a year. So if there are objections to these people, I would have expected that those objections would have been raised before now with respect to anybody on this list, because this list is a pared down version of the list that Your Honor has been, and we have all been working from for the last several months.
And Your Honor, I'm not going to, although I haven't looked at this, I'm not going to disagree that this list includes names or comprises names that have already been provided to us. I'll take the state's representation on that. All I'm saying is as far as any of these witnesses being a waste of time or cumulative, I need to really look at this list before I raise any issues with respect to that, Your Honor.
And Your Honor, with respect to the defendant's opinions about wastes of time and cumulativeness of witnesses, I know that the court is aware, and I'm certain counsel for the defendants are aware, that the state alone has the burden of proof and they cannot. The court has control over the order and presentation of the evidence, but I would think it quite presumptuous for a defendant to be able to assert to the court, when I'm certain he'll argue in the end, they didn't bring you this, or they didn't bring you that, or there wasn't enough evidence. I would find it quite presumptuous to argue that, or presume themselves able to tell the state that a witness is cumulative or unnecessary, when they will be quick to say and point out the fact of the matter that they do not have a burden of proof. We do, and we intend to meet that burden. And they are not able to, I would think, suggest to the court their best version, because I'm sure it would be much less than ours, of what witnesses we need to put up to prove what. And Your Honor, if we have 2 or 3 witnesses that testify about the same set of events, but from various vantage points, in no way could that be considered cumulative when, again, we have the burden of proof. And Mr. Weinstein's version of what's enough, I am quite certain will never equate to what I believe may be enough.
Well, I'll make that decision on a case-by-case basis. So that's part of my role and responsibility. So I'll take it up as it's presented. Okay. All right. Anything else? All right. Ms. Love, by 5 today, and like I said, please submit a response so I can read it before tomorrow morning.
Yes, Your Honor.
All right. Anything else on the witness list or anything? So we'll update the witness. We'll update the witness and evidence list. Mr. Kearns and I will work on an administrative order, and I will endeavor to enter that tomorrow. And so my goal for tomorrow is just for us to take up this motion to disqualify, and that's it. I don't think I have anything else. Is there anything else I missed? Councils? Yes, Mr. Steele.
Good afternoon, or good morning. Good afternoon.
All right, sir.
Your Honor, there is a matter that we'd like to take up with this honorable court, ex parte on a sealed record at the appropriate time today, if you don't mind.
Okay.
Thank you.
All right. Okay, I'll take that up as soon as we're finished. Okay. All right. Anything else, councils? Other than the ex parte matter? All right. If not, I will see everybody tomorrow morning, the 4th of April, for 9 o'clock. Okay.
Yes, Your Honor.
All right, we'll see you then. Okay, we're in recess.
Thank you, Judge.
All right.